one of my areas of focus and concentration is actually the Miami-Dade State Attorney's Office, led by Catherine Fernandez-Rundle, who has been the state attorney for Miami-Dade for many decades. Some of you may recall that last year there was a lot of press attention given to a number of cases involving prosecutorial misconduct and tampering with evidence and just a lot of unsavory activity, which was very well documented by the Miami Herald, by the way. And some of these cases went back many, many years. One of the defense attorney organization, one of the national defense attorney organizations, actually filed a formal complaint. In light of all that controversy, which, by the way, included a judge sending text messages to the state attorney, Catherine Fernandez-Rundle, which was not supposed to happen because it involved the judge's involvement in the case. A mess. Activity that should not happen. Okay, activity that should not happen. So last year was a very busy year, apologies, for Catherine Fernandez-Rundle and her team of state attorneys. And I was engaged in this conversation in the context of my organization and my advocacy on behalf of my son, Mitchell Finley, who was sentenced to life in prison after a one-night stand on Miami Beach in 2001, both of them in their 20s. He said, she said. She went into his hotel room, a hookup. She accused him of non-consensual sex. And she also stated that, she passed out, that he choked her. She thought she was going to die. The prosecutors, Miami-Dade prosecutors, offered him, actually they first offered him a 7-year plea deal, and then they reduced this to 5 years. And my son said, no, I'm not going to take it, I'm innocent. Had he taken that plea deal, he would have been out in 3. But he felt very strongly that innocent people don't take plea deals. So he didn't, and he went to trial, and he lost. And losing at trial is easier than you may think, especially when you're being accused of assaulting a woman. And especially when the prosecutor engages in inflammatory discourse during the trial. And especially when, let's say, the accuser puts on a good show. That's a fact, okay? I mean, this is before the days of Karens. Now everybody knows what a Karen is, okay? Look at the case, this recent case. In fact, today, this gentleman, what's his name? Ahad Fisherman. Other guys who are locked up now waiting trial in New York, and also accused here in Miami of assaulting a whole string of women over many, many years. And at the last minute, lucky him, he had a video proof of where he was at the date and time that the woman said that he pinned her down. I mean, people like to say, oh no, women don't fabricate. No, women don't perform. Please, okay? Unfortunately, they do. It's a disgrace, it's a dishonor, but they do. But he got lucky. He had a video. There was video evidence. If my son had video evidence, this thing would have been gone. But you know what? Even without video evidence, the plea deal tells a story. Always remember that. The plea deal tells a story. There's a reason why they went from 7 to 5, okay? Because the evidence there was so many question marks. She gave so many contradictory statements during deposition, during the arrest report, during the trial. She said this, then she said that, she forgot this, she forgot that. Prosecutors knew it was a weak case, but they know how to put together. They know how to pile it on. And one of the things that they do when they pile it on is what's referred to by the American Bar Association as the trial penalty. Look it up. Last year, the American Bar Association came out with a wonderful study showing that this practice of trial penalties, which is happening all over the country, this is not unique to Miami-Dade, this is not unique to Florida, this is one of those prosecutorial practices that is abusive, where when you refuse to take a plea deal, then they pile up charges and they go for the maximum whatever. And in my son's case, one of the charges was a life felony. In Florida, if you're convicted of what they call a life felony, that means you serve life. And in Florida, there's no such thing as probation or parole for life felony. In August of this year, my son was served almost a quarter of a century, 24 years, almost 24 years. And a lot has happened in those 24 years. And some of what has happened is very recent. And so the next series of podcasts, I will bring you up to date. But to give you a sneak preview, we're back in court. And this time we're back in court because we discovered through a wonderful investigator, through a paper trail, discovered that 1/3 of the jurors lied during voir dire. Now, those of us who are not lawyers, people like me, don't know what is a voir dire. Voir dire is the part that occurs in a trial when they first interview the jurors and they ask them questions. And actually, the jurors have to fill out questionnaires, and they ask them all kinds of different things. You know, have you ever been involved in this and that? Have you ever been arrested? Have you ever been accused? Anybody in your family? Any friends? You know, they sort of do this sort of verbal research where they ask you things about your life so that both sides, both the prosecution and the defense attorney, can decide, do we think that you can be a balanced juror, a fair juror, okay? And if there's something in your background having to do with criminal activities on your by members of your family, or things that you've suffered as a victim, or members of your family, there can be all kinds of situations where either a prosecutor doesn't want you on the jury because they feel that you'll be more sympathetic, or there'll be cases where the defense doesn't want you as a juror because they think that you'll be biased against them. So this happens in all trials, in all jury trials. But we only discovered this lie last year. Yeah, 22 years later. Because guess what? This is not an investigation where, you know, the investigator was hiding behind a garbage can, taking pictures, or, you know, sneaking around and asking people questions. No. It's all document research, deep document research. And I'm not going to get into all the details of that on this episode of this podcast, but I will tell you that because of that new evidence, because lying during the juror selection, you're not supposed to lie, okay? This is like really like a big deal, all right? You're not supposed to lie. This process of questioning and of jurors answering questions before they're selected, called voir dire, is a cornerstone of our criminal justice system. Okay, you can't simply have people go up there and say whatever. And this investigator discovered that 2 out of the 6, 1/3 of the jury, did not tell the truth, concealed facts that, had it been known, either the prosecutor would have kicked them off the jury and selected somebody else, or the defense, or both, because it was not acceptable if they had known that they lied. And the other thing is that other jurors that told the truth for similar type of backgrounds were not selected. It's an important process. So we're back in court. And what's astonishing, what's really astonishing about all this, I mean, it's astonishing on multiple levels, but one of the things that's really astonishing is that even now, with this evidence, the prosecutors, led by Catherine Fernandez-Randall, refused to do the right thing. We're asking for a new trial. But there's an alternative to a new trial. They can say, okay, let's cut our losses, we keep our conviction, and we release you. Okay? He's still going to have a tainted reputation, because once you have you've been charged and convicted of sexual assault, this follows you for life. But okay, but you have your freedom. They have the option of doing that, but no. They don't want to do that. No. Because this is an office that wants to win at all cost. And the only time they back down is when there's public exposure, frankly, when there's public exposure. And that's what happened last year, okay? I mean, the plea deal tells the story. Everybody knows that even people who do horrific things, they hurt children, they murder people, they maim people, they're given plea deals of 15, 20, 25 years for that level of criminality. There was no sex, there was sex, obviously, but there were no weapons, there were no drugs, there was no violence, there was no trafficking, there's not gangs, none of that. Straightforward, he said, she said, with a lot of racial connotation, I will add, during the trial, because I was present for that during the closing argument, which was actually quite disgusting. The kinds of things that you get away with a quarter of a century ago, you wouldn't be able to get away with today. And what's also extremely disturbing is that the same prosecutor who prosecuted this case a quarter of a century ago is the one who's insisting now on making sure that my son does not get out of prison, and that the prosecution does not admit that, you know what, we did so many things went sideways in this case, that the right thing to do is let him go. We offered him a 5-year plea deal, okay? We didn't do that because we thought that he deserved to die in prison. No, we gave him the trial penalty because, you take up our time, you piss us off, we're going to charge you with as many things as we can and take our chances that we can convince the jury to agree with us, which is not hard to do because, let's face it, we're conditioned, especially, maybe not so much today, but although I think today too is still the case, but certainly 24 years ago, we were all very conditioned that, if the police said something, it had to be true. If they accused you of something, it must have been true. That if a woman says something, of course it had to be true. I mean, as a society, we have a broader understanding and awareness of the complexity of the criminal justice system and the complexities of human beings, okay, and the things that people will do and say. We're more sophisticated in that sense. But it's unconscionable that you have a prosecutor who refuses to do the right thing, and that, even more importantly, the leadership, Catherine Fernandez-Randall, she refuses to do the right thing because she's the boss. Okay? She's the boss. She's the leader. She knows that everything in this case has so many things that just stink, including the fact that in 2015, a wonderful appellate attorney, Richard Klug, filed motions showing that life felony that he was convicted of, that life felony actually does not exist under Florida law. That the way the verdict form expressed the charge for which he was given a life sentence, that doesn't exist under Florida law. And you know what Fernandez-Randall's office said, the prosecutors, which of course she approved of? They said, too late, too bad, procedurally barred, time barred, which in legalese means too late, you should have noticed sooner. Go die. Next part, I'll go into more details about this case and about the investigation, about the jurors that lied. Again, my name is Evelyn Castillo-Bach. I'm the Executive Director of Balance Justice Network. Thank you.